Well, we know, or investigators say they know, where the oil that spilled into English Bay came from, the cargo ship Marathusa, but they're not going to determine if there's actually oil below the surface of English Bay until they're done with the cleanup up top. While remnants of the bunker fuel spill on the surface are now estimated at about half a liter, oil must still be cleaned from the waterline of the cargo ship, from the other ships in the bay, and the Canadian Coast Guard Assistant Commissioner Roger Girouard says that it's unlikely oil is below the surface because the fuel oil is meant to float, although scientists warn that bunker fuel can sink and the estimate of the remaining amount of fuel may be optimistic. So now that we know where the bunker fuel came from, who pays to clean it up? Well, Boughton Law is CKNW's on-air legal partner and analyst for 2015. George Cadman is a lawyer with the Boughton Law, works in civil litigation, and joins me on the line this morning. George, nice to have you on the show.
Good morning, John.
So what is the process now? We keep hearing that, well, it's going to be up to the owners of the ship to pay, but how do we make them pay?
Just by way of general background, Transport Canada have the overall oversight of the regulatory regime, but the Coast Guard coordinates all of the on-site work. And one of the things we heard on the weekend was the fact that the owner's representative is now part of the joint operations. One of the reasons for that is both on what I would call the water side, so federal jurisdiction, the polluter pay principle applies, and likewise on the land side, which is provincial jurisdiction, the polluter pay principle applies. What the significance of the owner's representative being at the table, and there will be, I would expect, an insurer's representative standing behind the owner's representative, is they want to make sure that the work that's being done is effective, and they want to monitor that because in the end of the day, they are responsible for cutting the check.
So does the insurance company then, by being on the scene, does it have any sway at all, any say in how the cleanup is being done? The ultimate responsibility for that cleanup rests with the Coast Guard as what's called the on-scene commander. Yeah.
But it is a joint operation, and really the role likely of the insurer and the owner's representative is to monitor, to ensure that there's cooperation, and actually to make sure that what is ultimately asked of the owner to be paid is correct.
Now, there has, as you know, there's been some criticism, politicians making criticisms, and members of the public over the length of time it took to notify certain parties that there had been a spill. The city of Vancouver, as an example, I think it was 16 or 17 hours. Does that kind of criticism, will that kind of criticism play into the final insurance bill that is ultimately presented? I mean, can the insurance company say, well, look, you guys took 6 hours or whatever it was to get on the scene. We're not going to pay for that because you guys were shilly-shallying around and should have been there quicker.
Yeah, I think that's highly unlikely. I think where that kind of communications issue does get analyzed, as we heard from the commissioner of the Coast Guard, is in what I would call the post-operations debrief. This is like any other joint operations emergency response. It's whether it's landside, for example, at an airport, or on a highway, or on a rail operation. There's always it's always a joint operation, a number of partners at the table. And almost invariably, there is a debrief process to deal with those kind of implementation issues. But the actual cost of the cleanup remains with the ship owner. And what's important, I think, for the public to understand is that in behind the ship owner, there's actually a whole series of international conventions that Canada is party to, and under those conventions, aside from anything else, there is what is known as the Ship Source Oil Pollution Fund, which is held nationally, contributed to by charterers and ship owners, and the most recent stats I was able to get my hands on show that there's about $1.3 billion sitting in that fund, which is a backup fund to the owner actually being able to pay for the cleanup.
What is would this necessarily have to wend its way through the court system? Is there any way that it can be sorted out just between the various parties?
So that will, I think the answer to that question ultimately lies with the ship owner and the charterer and the insurer standing the insurance, what's known as the P&I club that stands behind the ship owner on an insurance basis. It will, if they can't resolve directly with Transport Canada, who ultimately is responsible for monitoring those costs and recovering those costs, if they can't resolve that directly, then yes, it may well end up in federal court where there is what's called admiralty or maritime jurisdiction. And
so it would be a federal matter as opposed to going through the provincial system?
As a general rule, all of these matters involving shipping are within the jurisdiction of the federal court. One of the things that's important to remember, I think, is that this ship won't be allowed to leave its moorage, not only until it's cleaned up, but until those payment issues are likely resolved.
Mm-hmm.
So I don't think that ship's going anywhere anytime soon unless there is an accommodation reached in terms of payment for the cleanup.
All right, good stuff, George. I appreciate it very much. George Cadman, he's a lawyer with Boughton Law, and Boughton Law is CKNW's new on-air legal analyst for 2015. We appreciate his time.